call this meeting of the State Board of Elections to order. If anyone is joining us electronically, I would ask non-participants to mute their lines. I also would note the presence of a quorum, basically for our old and new quorum. Members of the department who are participating are Commissioner Piper and other members of the staff from the Office of the Attorney General. We have Carol Lewis participating. As noted on the agenda, public comment will be heard before the board takes action on each agenda item, with an opportunity for public comment on non-agenda items at the end of the meeting. Individuals will be recognized first by the sign-up sheet that is available here, then by those who signified their wish to participate by WebEx, and finally, for those who have signified their wish to comment by emailing to foia@elections.virginia.gov. Without objection, members of the public will be heard for 3 minutes and may submit statements for the record. The board is scheduled to receive an update from counsel on the status of pending litigation. And so without objection, we will receive general public comment before going into closed session. The first order of business on our agenda is approval of the minutes from our meetings of June 22 and June 30, 2021. Do the members have any corrections to the minutes as presented? If not, Secretary LaCruz.
Is there a motion to approve the minutes from June 22nd, 2021?
So moved. Second. It's been moved and seconded. All those in favor say aye.
Aye.
Opposed? The motion passes unanimously. Secretary LaCruz. Not on this side. Secretary LaCruz.
Is there a motion to approve the minutes from the June 30th, 2021 meeting?
So moved. Second. It's been moved and seconded that the minutes of the June 30th meeting be approved. All those in favor say aye.
Aye.
Aye. Opposed? The motion passes unanimously. Our next order of business is the Commissioner's report and a couple of very welcome introductions. Commissioner Piper.
Thank you, Mr. Chairman. You may notice that there are more of you today sitting at the table. It actually occurred to me, Mr. Chairman, just the other day that this body, the State Board of Elections, was founded in 1946. Am I right on that? Pretty sure. So we're at 75 years. It's been a 3-member board that entire period until today. So please join me in welcoming the Honorable Don Merritt and Angela Chang to the board. Welcome. Angela has served in a number of roles, but was a state employee at the small business. Is that correct?
Yes.
And then Mr. Merrick has been a delegate, and I actually got to serve with him a short time when I worked at the Tobacco Commission. So we go way back now. But I was really excited to see the addition of these 2 members. It's great to have more voices on the board, although I've always enjoyed your voices. It's just adding more wonderfulness to the pot. So glad to have them on board. I would like you to know, all 3 members to know that about 2 weeks ago, Angela and Don came to us and visited with us. We gave them the same kind of orientation that you all received a little about 2.5 years ago now. They're all schooled up on FOIA rules, and they're going to get a wonderful lesson in Stand By Your Ad today. You know, so they got the opportunity to meet with us. Yeah. And so, I think that they're more than ready. I know we have, both of them are incredibly knowledgeable, and we'll get up to speed real quick. And so excited to have them on board. Speaking of new persons, we have, I don't know that she could join us today, but we have a new external affairs assistant. Her name is Ariel McCullum, and she's working with Andrea Gaines in our new reorganized agency, focusing on voter education and outreach, working closely with the media, as well as our external partners in state government, federal government, and all over. So she's hit the ground running as well, and glad to have her on board. Today we're also joined by Danny and Leo. They are our some additional interns that we brought on board this summer. Suzanne is at the beach, but we've had some wonderful assistance from them, and they're all three head into college in the fall, so good luck to them, but they're getting a great education and opportunity to learn about all the work that's done here at the Department of Elections. A quick update, as you all are probably well aware, if not, the August 16th is the date that the state, or the Census Bureau, will be releasing data to the state about information that we use for redistricting. I'm sure you've seen the activities of the Redistricting Commission. There is a great timeline on their website of when, how the law works, and so we'll have a good idea of when the census, the information is available to us for redistricting, and that will, if you look at that timeline, assuming it doesn't go to the courts, it should be right around the time we're putting on an election. So, you know, that'll be fun. But we will have that as well, and we'll be working with that. We have a great plan in place for implementing redistricting and working with the localities on that process as well. You're well aware that the General Assembly has appropriated funds for updating, replacing our current VERIS system, VERIS being the central voter registration database that is maintained by the department. We are currently going through demonstrations from the vendors who responded to our proposal, and we'll be entering into a negotiation stance soon, and should have more to come this fall as well. So it's going to be a very, very busy autumn. In addition to putting on an election, we'll be working with redistricting data, as well as perhaps working to implement a new statewide voter registration system. More information to come on that once the information is available. As you know, yesterday started the second special session of the General Assembly for 2021. The budget bill is all that they'll be working on, as I understand it, and there are two items in the budget bill related to elections. One is $1.5 million for voter education, and then $3 million to expand early voting with Sunday voting. And so we are looking at those and waiting to see how the General Assembly proceeds on those particular items. More information to come should those items make it in the final version of the budget. Wanted to highlight that a few weeks ago, I think Chairman Brink and I think Vice Chair O'Bannon, you all attended Tabletop the Vote, or you did that? Bob did that. Bob, okay. Chairman Brink attended. It's another one in the series of exercises that the Department of Homeland Security at the federal government puts on, puts us through various scenarios of life-threatening and limb-losing kind of situations and how we respond and communicate. It's an important exercise that we do annually to make sure that we have thought through all of the various scenarios and communication situations that may come up, during, the election season. So we were happy to participate in that. Let's see, I think that's all. If I can take a moment of, personal privilege, there's one thing that's absolutely great about this job, just one. But as commissioner, I get to choose the color of the board, of the law book. And so the first year, I chose my favorite color, orange, just so everybody's aware. The second year, Deputy Commissioner Bowman chose blue. Last year, we chose purple for a presidential election. Purple is a good color for presidential elections. This year, my son was accepted to William and Mary. So we have green and gold this year. It's not related to money, although we like that in our budget. But I wanted to point out that the new law books are here. They are being delivered to the localities as we speak. You all get this one. You'll also get should you choose a version, bound version, so it's easy to open and close. But you can take these home for now. At the next board meeting, hopefully we'll have bound versions. And go Tribe! Thank you, Mr. Chairman.
Thank you, Commissioner Piper, and on behalf of Secretary LaCruz and me and your son and one of our summer interns who's about to take off for William and Mary, I appreciate the green and gold colors. Very good. Also, I want to second the remarks that the Commissioner made about our new members. I'm certain that my colleagues, Vice Chair and Secretary, or as I refer to us, the legacy members of the board, appreciate and welcome the Delegate Merrick's and Ms. Chang to the board. I think that I didn't realize that it had been almost 2.5 years since we started here, and I'm certain that the new members will come to appreciate how much I admire the people in the 133 localities who actually make elections happen. They've done a phenomenal job through the pandemic, adapting to changes that were necessitated by the pandemic, adapting to changes that were mandated by the General Assembly and the Governor, and I think that we owe all of them a tremendous debt of gratitude for their diligent and professional and ongoing efforts on behalf of election administration. Now, one of the board's ministerial duties is to assign certificates of election after the election. This year, it will entail all of the statewide offices plus 100 members of the House of Delegates. Are there any more than that, Mr. Commissioner?
There are no shared constitutional offices this year? Nope. So that's it.
Okay, so it'll be a mere 103 times that we have to sign our names. Now, a couple of weeks ago, Nancy Rodriguez, who was the Secretary of the Board under Governor Kane, and then was Secretary of Administration under Governor McAuliffe, was cleaning out her closet and discovered a little cache of pens that say Virginia State Board of Elections. She forwarded these to me, and so in anticipation of the writer's cramp that you all are going to have, I'd like to give each one of you one of these pens, one for you, Madam Secretary, and one for Delegate Merrick's. And so get ready for, I guess it'll be our December meeting, or no, our November meeting, when we're going to have the task of signing our names 103 times. Do the other members of the board have any questions or comments of the Commissioner on items that he's touched on his report? If not, our next order of business is a series of complaints that were filed under the stand by your ad provisions of the code. Ms. Alexander, here we go.
Good afternoon, everyone. I don't think this is on. You need to be on. Okay. All right. I'll go ahead and get my big old notebook with all of its colors ready for you. Thank you. Okay, today, and hello everybody, and welcome to Stand By Your Ad. And I like that we're finally at the top of the agenda where we should be. So if you'd all look at your papers, did you receive your extra pages, Franchelle? Did they get those? Okay. And I also gave you a copy of the new board policy regarding Stand By Your Ad, if you want to reference that. Our first case before us today is Dana Sally Allen for Richmond School Board. We have a PowerPoint coming. Okay, we have before us, we have two items that were brought in as a complaint. It was no disclaimer listed on the campaign flyers for more than once, as I put that exactly the way it's in the complaint. But it's been determined that it's only the one flyer now, this one with the purple background. There is no disclosure. It happened outside of the 14 days. And if we go to the next slide, please. We have the response from Ms. Allen that the purple flyer was not produced by her campaign, but she did receive it, and she did hand out the one that we were looking at previously. 2 slides back, please. I'm going to make it bounce all over. Sorry, Franchelle. So she did receive that as a gift from someone who thought she didn't have anything to hand out. So they created this for her, gave it to her, and she said she did give it out at that one particular meeting. So this is not something that she actually produced herself, that she paid for. But by handing it out and accepting it, she in essence authorized it. So that is brought before you today to determine what we are going to do with it. If we go back again, please, Franchelle. These are the actual items she produced. And you see on the bottom it says, paid for by Dana Sally Allen for school board. So she is aware of the rules, and she did it on what she produced herself. Yes.
Can you go back to the second one, please?
Sure. And Miss Sally Allen is not with us today. I have met with her, and she realizes what she has done. And so we have the relevant facts. This is her first time before the board. She's a local candidate, so the penalty would be $50. It's just for the one advertisement. But if the board unanimously agrees, it is only a $25 penalty.
Ms. Alexander?
Yes, sir.
Could you explain the significance of the outside of 14 days?
Oh, I'm sorry. If you're within 14 days of the primary date or the election date, the penalties are doubled. So instead of a $50, this would be a $100 penalty. And I should remind you as well that these are initial hearings we have, because we've adopted the new policy where we're going to have the meeting, get the initial ruling, and then we have days to finalize.
So you're not looking for a motion from us today?
I am looking for a motion today, yes.
Right.
which is why I recommended a motion.
All right. And could you review that, please?
Yes, the motion I have, suggested is I move subject to the board's authority under the Code of Virginia, section 24.2-955.3, to fine Dana Sally Allen in violation of 24.2-956, stand by or add print media disclosure requirements with regard to one print media advertisement and to assess a dollar amount of civil penalty of your choice. So your choices are $25 and $50 according to the penalty schedule we adopted on October 20th of last year.
All right, do any members of the board have questions of Ms. Alexander?
I have a generic question. Maybe for council. Help me remember if we're taking a vote now, why do we need to delay and, just so we understand that?
I don't know if this will pick me up. Oh, there we go. Okay, thank you. So that is the process under the Administrative Process Act that says you make an initial decision, come to all of your fact findings to determine if there is enough information to support your initial decision, put together an order that is then given to the person who was complained upon.
So we don't do anything else unless they...
So you come to an initial decision today and then come to the rest of the facts and make a full reasoned explanation for your decision if that has not changed within a certain amount of time, and then a written order is given to the person who was complained about so that there is a full record of your decision-making process.
I think it's to give the person time to present additional evidence. Okay.
Come back in.
Yes.
Okay. You'll forgive all of us. This is the first time that we're going through Stand By Your Ad with the new policy and procedures that we adopted earlier this year, and so we're new on this also.
Yes.
Now, Ms. Sally Allen has submitted material, said that she couldn't be here today due to personal circumstances.
Mm-hmm.
Does any other member of the public wish to be heard on this item? If not, I will entertain a motion on this complaint.
Mr. Chair, I have a motion. I would move subject to the board's authority under the Code of Virginia 24.2-955.3 to fine Dana Sally Allen in violation of 24.2-956 Stand By Your Ad and media disclosure requirements with regard to one print media advertisement and to assess a $25 civil penalty.
Is there a second?
Second.
It's been moved and seconded that the board assess a $25 civil penalty on this complaint. Do any members of the public wish to be heard at this time? If not, I'll call the roll, or have the secretary call the roll.
Chairman Green?
I vote aye.
Vice Chair Dr. O'Bannon?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
And Delegate Merritt?
Aye.
The motion passes 5-0.
Thank you. Now we move along to Gore for City Council. The complaint was, I have attached images of a campaign mailer that was sent to Ward 4 residents with no postage, along with a sign of hers that does not state the campaign disclosure of who authorized/paid for the sign. There are at least 6 signs in Hopewell that look like this one, and this is the second mailer I have received by the post office without postage. We are not here, SBYA is not concerned with postage, so we're not going to worry about postage. And if you look at the information presented, I have, it's the back and front of the same flyer. So there's only one piece of literature, and then we have the sign. And if you look at, let's see, you go 2 slides over, please. 3 slides, excuse me. 1 more. Wait, oh, 1 more, sorry. If you look at the bottom, you can see where it's ragged on the bottom. The sign has been altered. I'm not sure what happened to the bottom of the sign, but, so I think Ms. Gore is here today, because right now, we are only looking again at the 1 mailer and the 1 sign. But Ms. Gore has told us that the sign looks like it has been manipulated. She has also said that this was not the color scheme she used for this year. So, and then if we go back to the flyer itself, so pop back to, next time you'll have me drive, won't you? I have enlarged the part underneath where it says re-elect Gore. In case you were wondering what that fuzzy line was, it says to Hopewell City Council Ward 4. I was looking to see if maybe that was possibly the disclosure statement, but it's not.
Any additional information on
No,
the complaint?
Ms. Gore may be with us today, I'm not sure.
Okay.
I'm present.
Oh, Ms. Gore is with us.
Very good.
Should we have her come up, or
Um,
ready, or?
do any members have any questions of Ms. Alexander before we hear from Ms. Gore? If not,
Okay. Come on up, Ms. Gore.
Thank you. Good afternoon.
welcome.
When I inquired about how to prepare for this meeting, I was told that I can present something in writing to the board members at the hearing. So do I give that to Ms. Lewis?
Thank you. I'd like to find people like one of you individually. I'll do that.
Thank you.
So, thank you.
So, thank you for allowing me the opportunity to, defend myself against the allegations poised for today's hearing. I provided hopefully a brief synopsis of my defense for this hearing. The first, I did want to challenge the timing of the hearing. One, per the current policy of the Stand By Your Ad, hearings will be held in January for those that were submitted in October, and this is in August, which is almost 2 months to the day, a year, this complaint was submitted. Additionally, along those lines, I know you adopted a new policy in February. My other concern is a new policy being applied to a retroactive complaint. However, we're here, so we'll move forward with with the other issues. I move on to, on page 2, the complaint in particular about the postcard. If you look at the image right there on the right-hand side of the screen under my face, you will see paid for and authorized by Gore Ward 4 and or Gore for City Council on the postcard. And if you want me to walk through it, it's right here, the disclaimer. So it's visible in the information that was submitted for the complaint, and it is clearly visible on the postcard. My concern regarding this is, according to the new policy, if an investigation is conducted and the complaint is not valid, it doesn't have to warrant a hearing. I would argue this is the case with this particular complaint because this is visible. Moving on to the yard sign, I was told upon entry that I couldn't bring signs in here, so I left them at the door. As Ms. Alexander stated, this sign has been manipulated. If you look at the picture, you can see it's clearly weathered. It is the old sign. I've been elected since 2012, and this sign says vote for Gore. This is my 2012 sign. I do not know how it got put up. We did not authorize for it to be put up. I was not aware that it was up until now. I took pictures. It's not in here because I was bringing the signs with me, but I took pictures at the door of my 2020 sign. I can just hold that up for you. It clearly has a disclaimer on my 2020 sign. Also, the layout of the sign is completely different, so there can be no confusion. If you look here,
Yeah, I'll take it to him.
she told me.
Well,
Okay.
I'll take it.
Okay. It's a touch screen, so if you touch it, gonna move.
Okay,
Oh, well, it's very evident.
So I had 3 different yard signs for 2020. One is a big billboard sign that's in yards. One is 24 by 18, and then one is a vertical, a sign that goes like this. Both signs have the disclaimer clearly on it. If you look at it again, it says re-elect Gore. It's a completely different sign. And the other point that I would argue, if you look at the documentation, I don't have the policy in front of me, but in your packet you will have that, thank you. Signs that were printed and disseminated in 2012 are not eligible for the Stand By Your Ad law. It's signs that were printed and disseminated after July 2015. So according to that law, again, this doesn't qualify for that, even if the fact that it was clearly manipulated doesn't count. In the last page in your packet, I do raise some concerns about the hearing itself and some of the allegations posed. I'll keep those brief. If you look at the final page of pictures, you will see that the person submitted the complaint. We submitted several complaints during the election cycle to staff of the state Department of Elections and to our local election registrar's office. The first picture is the person that submitted the complaint had signs printed, no more Gore for Ward 4, hashtag Ellis City Council, no disclaimer on those printed materials. That was submitted. There is no hearing. The second picture beside it is my yard sign that was clearly cut in half and manipulated. We submitted complaints about people manipulating my yard signs and taking them. Nothing was done with that. The last picture in the corner is signs blocking the right-of-way with that same opponent. Nothing was done with that. And then there's the bottom picture of the yard sign that I said that was too big to bring in here. Lastly, I would say that we did also raise concerns about professional and personal conflicts. We had a secretary of our local electoral board office actively campaigning for the person that's in this complaint for office, and so that never reached the board. We submitted concerns regarding ethics violations there. And so I ask that you consider this to be dismissed, and then also look into why those other complaints related to the same organization of people were not brought before you when they're clearly serious in nature. And so that's all I have, and I would like to submit a formal complaint as well that would reach you, the chair, if possible, so that way we know that it's gone directly to the sources that it needs to go to. And that's all I have. If you have questions.
Do members of the board have any questions of Ms. Gore?
I don't have a question, but I'd like to make a statement if I could. Mr. Chairman, this Department of Elections is doesn't control right-of-way, signs. Further, we're not an ethics office, we're an election administration office. I did respond to that complaint, regarding the campaigning. Secondly, any manipulation of signs should be reported to the police. It is not managed by the Department of Elections or the state board. So I just wanted to clarify those issues. While I appreciate the frustration you must have felt, they weren't in the realm of the Department of Elections nor the Hampton or Hopewell Electoral Board. I just wanted to clarify that for the board.
Thank you, Commissioner. Do we have any additional questions or comments?
I would say if it's possible, that, as a local elected official, when you have complaints regarding electoral board staff and then some other members of staff, that there should be a process to submit those, even if it's board staff for your organization as well. Because it does impact how elections are ran, and there are guidelines with the General Registrar's Office, and so even if there may not be an existing policy, perhaps, if it comes down to how elections are organized and managed, you should consider looking at some other means, because it can, as you know, be very political, and some concerns are not being reached to the ears that we would like for them to be.
Mr. Chairman, if I might, I do also want to point out there's no prohibition on local electoral boards campaigning. So I wanted to make sure that was clear.
Yeah, that there isn't. Maybe it should be.
Thank you. So is it your contention that sign is from 2012?
Well, it's my contention that I did not authorize for this sign to be put up, and I did not know it was up. But the sign is from 2012, and so if I were to be held liable for this, even though I did not authorize to know it was up, I would argue that the code section doesn't apply to this because signs, printed and distributed earlier in 2015 are not applicable by Stand By Your Ad.
This may be a dumb question, but how do you prove this from 2012?
Well, I can submit the proof of the signs when I got printed. I can give you my 2016 yard signs, my 2020 yard signs. Like I said, they're outside in the lobby. But then also, I've been elected since 2012, so my signs from 16 and 20 say re-elect door 404, and they're completely different models. But even still, I would also, challenge, the sign has been cut at the bottom, and so it opens the door for anyone to cut yard signs and then submit a complaint, and for someone to say, I didn't authorize the yard sign being cut and put up in someone's yard. But even still, I didn't know this was up, and I did not authorize it, and it is an older sign, sir.
Additional comments or questions? Does anyone else from the public wish to be heard? If not, I'll entertain a motion on this matter.
No, you need Ms. Alexander to come back.
I'm sorry. Ms. Alexander?
Yes, in light of the information that Ms. Gorse presented, and I do apologize because in all of this writing on the card, I did miss that paid for and authorized. It was not, well, as we would say, conspicuous, but it is clearly there. So I would suggest that we take that off the complaint at this time. And I did check that Ms. Gore did run in 2012. So we do know the sign has been manipulated. And not only that, we know that before 2015, or July 1st, 2015, that they were not required to have that paid for and authorized on the bottom. So if my recommended motion at this point with this new information would be to dismiss this.
Thank you. Additional comments or questions on this matter? I have to say, as someone whose initial yard signs said Bob Bring for delegate and whose subsequent ones said re-elect, I have a certain amount of sympathy for dated yard signs.
Mm-hmm. We'll see a lot of dated yard signs over the years together.
Right. So would this require a motion to dismiss?
Yes.
So moved.
Been moved. Is there a second?
Second.
Okay, it's been moved and seconded that the complaint be dismissed. Secretary Cruz, will you call the roll?
Chairman Brink?
Aye.
Vice Chair Dr. O'Bannon?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Mayor?
Aye.
The complaint is dismissed by a vote of 5-0.
Thank you. All right, that brings us to Hampton Roads Black Caucus. I received a reply from them. The complaint was no paid for or authorized on a sample, and it's on white paper. We are going to look at the fact that it was not paid for, listed as paid for and authorized by. Underneath there is a light line under HRBC that says, well, it says Hampton Roads Black Caucus, and underneath it then lists the locality, so that is not a disclosure statement there. With it being on white paper, this clearly is not a sample ballot. It's just simple literature, so we're not worried about that. It happened within 14 days of the election. It happened on election day, actually. The HRBC has contacted me. They have sent me a letter. They admit that this did occur, and they apologize and say it will never happen again. And I don't believe we have anybody here with us from the HRBC. It looks like we do not.
Okay, does anybody, any member of the public or from the HRBC wish to be heard on this item? Do members of the board have any questions or comments of Ms. Alexander on this complaint? If not, what is the recommended?
All right, well, our relevant facts in this case are, this is the first time they're before the board. It concerns local candidates, so we have the option of reducing it, or you have the option to reduce it to $25. It's only the one advertisement. It did happen within the 14 days of election, so we do have to double it. So it would be a $100 penalty if you decide not to reduce it. It will be a $50 penalty if you unanimously agree that this does not bring harm to the voting populace. So the recommended motion is, I move, subject to the board's authority under the Code of Virginia of 24.2-955.3, to find Hampton Roads Black Caucus in violation of 24.2-956 Stand By Your Ad print media disclosure requirements with regard to one print media advertisement, and to assess a either $50 or $100 penalty, civil penalty.
Thank you, Ms. Alexander. Does anyone have a motion?
Can I ask a question before?
Sure.
moving forward? Do you have any information as to whether the candidate on this flyer, knew that this organization was going to be sending this out, or?
I don't.
That's all, thank you.
Anybody have any additional questions or comments?
I have a question. It doesn't say anything about elect or re-elect or any election referenced here, right?
It mentions candidates' names, the locale, or the specific districts they're in with their name, and it was handed out on election day to, voters as they entered the precinct. So it was kind of unambiguous about what this piece of paper meant.
Well,
Members have additional comments or questions? Any member have a motion?
Member Chang, that would be under express advocacy, where there is no question about what that is. So I'm sorry, that is at the beginning of our presentation. It's 1 VAC 20-90-30. It is, 5 pages in on the presentation. And that explains express advocacy. That's where you have the support, elect, for, and it also goes for the unambiguous meaning of the document. And so, like it said, if it was against someone, it would be like pummel Paul with the polls. We know that's express advocacy, so.
That's what makes Stand By Your Ad so much fun.
If you're willing to talk to people in the General Assembly to change it, I'm more than happy.
Wait till we get to conspicuity. All right. Does any member have a motion?
Mr. Chairman, I would move, subject to the board's authority under the Code of Virginia 24.2-955.3, to find the Hampton Roads Black Caucus in violation of Code Section 24.2-956, Stand By Your Ad print media disclosure requirements with regard to one print media advertisement, and to assess a $50 penalty.
Is there a second?
second.
It's been moved and seconded that the board assess a $50 penalty. Any member of the public wish to be heard on this? If not, Secretary, can you call the roll, please?
Chairman Brink?
Aye.
Vice Chair Dr.
Aye.
Secretary Cruz? Aye. Ms. Chang?
Aye.
Delegate Merritt?
Aye.
The motion passes 5-0.
All right, thank you. All right, we are almost halfway done. Leonard K. Harris Sr. for House of Delegates. The complaint was Leonard Harris' campaign had 6 signs at the registrar's office during early voting. I am attaching photos of 3 of the signs without campaign finance credits. In the presentation to you, I have only included 2 signs because the other sign was taken at such a distance that you could barely tell who the candidate's name was. So it's not fair to the candidate to judge them on something that wasn't even presented that well. These, I could zoom in enough, and these do not have disclosure on them on either side. I happen to have seen these in person. It's just the 2 signs. The violation date was June 5th. The primary date was June 8th, so it was within the 14 days. So the penalty will need to be doubled. This is a House of Delegates, so it is a statewide office. The first penalties for this would be $100 for the first time before the board, and doubled because of the proximity to the election. So we have 2 signs. It would be $200 doubled to $400. I have not heard from Mr. Harris's campaign at all. Oh, okay, he's here.
Members have any questions of Ms. Alexander before we hear from Mr. Harris? not, Mr. Harris? Welcome.
Thank you very much, I appreciate it. I'm not gonna take too much time. I will say that, the signs that you see were actually painted by a friend of mine that was trying to help. So they didn't know the proper protocol, which I did. So when I did see the signs, you know, I was contacted, I did remove them. But it wasn't until actually election day when someone told me that the signs weren't even up there. So all I can say is that that won't happen again, should I run again, but, that's pretty much it.
Thank you, Mr. Harris.
Thank you.
Thank you.
Members have any questions of Mr. Harris?
This may be Ms. Alexander's commissioner, but there was a time when we could give credit for mea culpas. Is that no longer?
There's nothing in code that says you can't, but in 2010, or in 2020.
Okay,
Yeah.
thank you.
And I'm sorry, it was 2020, I meant to say 10/20 for 2020.
I just had a question for, Ms. Alexander. Who filed this complaint? Is it clear?
Excuse me, thank you. Sarah Johnson, Ward of Midlothian.
I think they've given us this microphone, so we're on our best behavior. Additional, comments or questions of Mr. Harris or Ms. Alexander? Thank you, Mr. Harris. Additional members of the public wish to be heard? Ms. Alexander?
Okay, as Dr. O'Bannon has mentioned, that there is nothing that prevents you from lowering the standards, but this was just adopted on October 20th of 2020, these present rates. So the recommended motion is I move subject to the board's authority under the Code of Virginia 24.2-955.3 to fine Leonard K. Harris in violation of 24.2-956, stand by your ad print media disclosure requirements with regard to one, that should be 2 print media advertisements, and to assess a $400 penalty.
Thank you.
Mr. Chairman, I'd like to speak to it.
Please.
Thanks. I move subject to the board's authority under the Code of Virginia 24.2-955.3 to find Mr. Leonard K. Harris in violation of 24.2-956, stand by your ad print media disclosure requirements with regard to one print media advertisement and to assess a $400 civil penalty.
It's been moved that the board assess a $400 penalty. Is there a second?
Second.
Been moved and seconded.
So I appreciate Mr. Harris coming. We've been through this now for the last several years, and we had lots of machinations in trying to make it consistent. So I think we actually have a better process now. Unfortunately, that's actually fortunately where we are. Anyway.
Thank you.
And Dr. O'Bannon, I would like to say that it should say 2 print media advertisements and not 1, and you stated 1. Do we need to have that updated, Carol, for the
I'd offer that as an amendment if possible.
Okay,
So noted.
thank you.
All right. Additional comments or questions from the board? If not, Secretary of Cruz, will you call the roll?
Chairman Green?
Aye.
Vice Chair Dr. O'Bannon?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Merrick?
Aye.
Motion passes 5-0. Ms. Alexander?
Thank you. Number 5 5, Friends of Reggie Ford 2020. The complaint is there is no disclaimer on the material left on my doorknob. Both sides are identical. These signs are popping up all over the district, but have no disclaimer on them front or back. What was sent in was the one door hanger on the left and the two signs. So we have 2 signs in this complaint and 1 door hanger. They both occurred outside of the 14-day window before the election. So they are eligible to be reduced to $25 each for the 3 advertisements. So that would be a penalty if you were to not reduce it, $150 penalty, or if you reduce it to $25 per violation, it will be a $75 penalty. And I have not heard from Mr. Ford. I'm not sure if he is here with us today.
Is Ms. Ford, present today? Does any other member of the public wish to be heard on this item? Members of the board have any questions of Ms. Alexander? So the recommended penalty is $150 or reduced.
Or $75 for his first time before the board.
All right. I'll entertain a motion on this complaint.
Mr. Chairman, I would move, subject to the board's authority under Code of Virginia 24.2-955.3, to fine Reggie Ford in violation of 24.2-956, stand by your adequate media disclosure requirements with regard to 3 advertisements and a penalty of $75.
It's been moved that the board assess penalty of $75 on this complaint. Is there a second?
Second.
It's been moved and seconded. Any additional comments from the public? Any additional comments or questions from the board? If not, Secretary Cruz, will you call the roll?
Chairman Green.
I vote aye.
Vice Chair Dr. Lynn.
Aye.
Secretary Cruz. Aye. Ms. Chang.
Aye.
Delegate Mayor.
Aye.
The motion passes 5-0.
Thank
Ms.
you.
Alexander?
All right, we're now in the home stretch. We have Team Virginia Beach. The complaint is, the current authorization paid for and authorized by the candidates is incorrect. There needs to be an authorization from a singular PAC. Please see link above and attachment. Now, it could be a PAC, or it could be the 5 candidates getting together to create a sample or a piece of literature. I have contacted all 5 candidates. We have Mr. Gary Byler here today to speak on behalf of 4 of the 5 candidates, but it is just the 2 documents. One is what they call a sample ballot, but again, it could not be confused for an actual ballot. It's not like they're gonna walk in the precinct and do this. And then the little flyer or the little hand card with their pictures on it. And Mr. Byler here is with us today, but this would also be a $50 per violation, or 25 cents. This is the first time for all 5 of them to be here. I mean, even individually, this is their first time. So it would be, you could reduce it down to $25 per violation, which would make it just a $50 violation altogether, $50 civil penalty. And I know Mr. Byler would like, oh, I'm sorry, go ahead.
I was just going to say, I'm going to recuse myself.
Okay.
All right, additional questions of Ms. Alexander? All right.
All right, you ready for Mr. Byler?
Well, welcome new members, and to the legacy members, I bring greetings from former Secretary Cameron Quinn, who is about as confused with these directions and definitions as the rest of us all. I'm here honored to represent Councilwoman Rosemary Wilson, Eric Ray, former Councilwoman Jessica Abbott, and Councilman Mike Berlucci. Unlike some of the other matters you had before you today, this does have a disclaimer. It says paid for by the candidates. Their pictures are pretty clear. I reached out to Ishmael Meeks, who filed the complaint. Got no problem with him. He was a paid political consultant for one of the others. Mr. Meeks, I can tell you as an officer of the court, personally knows these 5 people by their pictures, so there was no actual confusion. Mr. Meeks did not return my call, which is fine, but it's important to know there was no actual confusion. We're balancing 2 very important things here. The public's right to know who's paying for things, and not chasing citizens out of running for these offices, like we've seen these wonderful people today, that you gotta hire 3 lawyers. If you put your picture on there and say, I authorize this, seems like it's standing by the ad. But of course, as lawyers and commission members, it's never quite that easy, and speaking with counsel, staff counsel, Ms. Alexander, we find no previous violations on any of these, and some of these people have been around for decades. So it's obviously the compliance with the new rule. Sure, 24.2956.1 is what we're talking about, but when you go back, authorized by person or committee, well, we're saying by candidates, that doesn't list the person. Kind of does, because all the names are right up there. You go back and sponsor in the same ad, I think, adds supports to our argument. But if you go to 94.2.945.1 definitions, authorization definition and person, both seem to be, if not in our support, at least confusing enough, I think, to justify a dismissal. We certainly, I've spoken with several of these elected officials, and one in the hallway coming up here, as well as council, and we're happy to work with you folks to get language that works for everybody. But obviously, if you're a citizen and you run and you say, I authorize this, and you have your picture on there, they felt like it was covered. I will tell you that my 4 clients, and I assume that Mayor Dyer, all rely on a paid political consultant, Lord save us from paid political consultants, for their advice in complying with the statute. The fact that there have been no priors despite many elections, the limited distribution, I don't think there was ever a physical copy of this printed. My understanding, it was somebody got an email, clear reading of the matter. I would also say that the fact that these folks took it seriously enough to send counsel here should impress the commission that, 1, they're not doing this haphazardly. Number 2, they will put on a 3-line disclosure next time if that is what the board wants, and try to get pre-clearance. So we believe it is in the discretion of the board to dismiss, both because of the confusing nature of the code, the fact that there is a disclaimer of the person. It doesn't list the 5 at the disclaimer, it lists them about a 1/4 of an inch up. But we believe that since it's on the same piece of paper, that should qualify. And again, the decision-making process, as the Attorney General representative talks to you about, I mean, this is a semi-judicial proceeding. So if there is any confusion as to the definitions and you think there has been a good faith compliance, it's certainly in with this board's discretion to dismiss these, and we ask that they do so based on the reasons I've given.
Thank you, Mr. Bauer. Do members of the board have any questions of Mr. Byler?
I have a question.
Ms. Chang?
If we had one picture of a candidate, and is the statement of pay or authorized by the candidate is acceptable without a name?
According to the code, and let's see, I know you all have your new code books, so let's go ahead and open them up. On page 486, so it's 24.2-956, section 1. It bears the legend or includes the statement paid for by, and then it lists the name of the candidate or campaign committee as it appears in the statement of organization. That's what the disclosure statement should say.
Thank you.
It would be our position that the name is clearly stated on the face of the document for all 5.
Mr. Chairman, I shared this with the chairman. I don't want to look like I wasn't sharing with everybody. But if you go to, I'm sorry, I don't have the book in front of me, but if you look at 24.2-955.3, subsection E. It states, "It shall not be deemed a violation of this chapter if the contents of the disclosure, legend, or statement convey the required information." And it would, obviously, we as a department can't determine that, but the board can, I believe. And it's a question of whether you think that this information conveys the required information.
Thank you, Commissioner Piper.
Mr. Chairman, personally, I think this is just, anybody that's got any common sense at all can read this. And, I think, I would move that we, whatever the motion is to dismiss or whatever, I just don't think it's right to charge them. I think the intent was there, and I think anybody in their right mind can understand.
So that's it. You're making a motion to dismiss the complaint? Is there a second?
I'll second.
I moved and seconded that this complaint be dismissed. Any additional questions or comments? If not, Secretary will call the roll.
Chairman Brink,
I vote aye.
Vice Chair Dr. O'Bannon,
Aye.
Secretary LaCruz abstained, Ms. Chang,
Aye.
Delegate Merrick.
Aye.
Motion passes 4-0 with one abstention. Ms. Alexander?
Thank you.
Thank you, Bob.
And we come to our conclusion for the day. Youngkin for Governor Incorporated. The complaint, the Waynesboro Republican Party has posted the attached photos of signs and T-shirts available at their headquarters. The signs have very small text to identify the committee, and it's blurring and runs together. The T-shirts don't seem to have any reference to the committee. The attached screen grabs from their Facebook page provides the evidence. Thank you for your consideration. We did hear from the committee. They do admit that they did not have disclosure on the T-shirt that is present there, but they have since, they immediately went out, and if you go to the next screen, you will see they are very much so in compliance now. And so this would be a first time before the board, statewide candidate, $100 for one T-shirt.
So there were no signs submitted this time?
No, the sign actually has disclosure. When I opened it up, I immediately saw where the disclosure was on the sign.
Okay.
It doesn't show it well on the presentation.
I've seen a lot of times and the disclosures were not correct, but that's probably a separate issue for a different day.
That, yeah, because the ones I have seen, there was a disclosure, and then other ones were like, yeah. But nobody complained about those, so.
Not me.
So I only bring before you what is brought before me.
All right,
I believe we have someone from the Youngkin camp here.
right, that was going to be my next question. Is there?
Oh, he's like that now.
Ah. Got it. Now, the board received a letter from the Youngkin law firm.
Yes.
Dated July 29. And in one of the footnote on the first page says, specifically, we ask you to treat this letter as a request for summary case decision under 2.2-420-1. There are no material facts in dispute. And the letter constitutes a proposed stipulation of all undisputed material. Do you know whether or not this is a case of first impression?
This is the point where I'm going to have to swing you over to an actual lawyer. Ms. Lewis?
Mr. Chairman, to my knowledge, this is a case of first impression for the board. You do have the discretion, because this is an initial hearing right now. You do not have to go to a summary case decision. You can find to charge a fee right now or not, or you can grant the request for a summary case decision after 21 days, so you have time to think about it. Under a summary case decision, briefs would be submitted by the two parties if there is a question of law.
Dr. Van,
So can somebody define first impression for a non-lawyer?
The first time that an issue like this has come before the board. So the first time that a summary case decision has been requested.
are there additional comments or questions from members of the board about this complaint? Okay. Well, I was going to ask Ms. Lewis to repeat what our options are.
So your first option would be to decide here today whether you are going to assess a fine or not, or you can grant the request for a summary case decision, which would require further time and briefs to be submitted, and you would also have discretion to hear oral argument on the matter. So that would be a longer process.
All right, the firm does offer an alternative. This letter should serve as rebuttal proof of proposed findings and conclusions under Virginia Code 224020C and D, and the Youngkin campaign should be excused from any requirement to have a representative attend or appear at the hearing scheduled for August 3, 2021. I've just gotten very bad flashbacks to law school 40 years ago. All right, so those are our options in this case.
So they're asking us to move forward, but if we continue the matter, it sounds like they wouldn't respond. You know, they're asking to be excused.
Correct.
Okay.
All right, do I hear a motion on this matter?
I'll try it. I'll move for a summary case.
I'm sorry, Chairman.
I can withdraw that.
I believe my interpretation is that what they are really asking for is just for a decision today. If there was some sort of dispute about the law, then they would ask for the brief. But they are also saying that this letter should serve as their representation at the initial hearing.
All right, Dr. Banner?
Glad I'm not a lawyer. I'm subject to the board's authority under the Code of Virginia 24.2-955.3 to find Youngkin for government in violation of 24.2956, stand by your ad print media disclosure requirements with regard to one print media advertisement, and to assess a $100 civil penalty.
It's been moved that the board assess a $100 civil penalty on this complaint. Is there a second?
Second.
Been moved and seconded. Any additional comments or questions from the board? If not, Secretary Cruz, will you call the roll?
Chairman Brink,
I vote aye.
Vice Chair Dr. Manis,
Aye.
Secretary LaCruz, aye. Ms. Chang,
Aye.
Delegate Merritt,
Aye.
The motion passes 5-0. Does that complete stand by your ad for this?
It absolutely does, and I want to thank you for your patience with me on my first time doing it, and I think you all did a fantastic job, so thank you very
You
much.
did a stellar job
I
as
have a
well.
question. I think you did a really good job.
Part of the team.
Can we discuss wardrobes for a second?
Mm-hmm.
Do these, obligations pertain to pants and socks and hats and?
Well, that's when we start to look at kind of what the federal government has done. It considers what is a novelty item or what is worth nominal value. A pair of socks, it's going to be hard to put an authorization form on a pair of socks. Same thing with pants, but a T-shirt, these days they can be custom printed. There's no reason for them not to have it. Same thing with the hats and things like that. Now, a pin or a lapel tag, they're small and they're going to be hard to do, and they have no intrinsic value. But a T-shirt can be worn for years, so it does have some value.
Thank you for that answer. May I have a point of personal privilege? After reading our book, I actually went to the Terry McAuliffe for Governor website and found some hats that I think probably have some advocacy, but I'm not filing any complaints.
You're not filing, okay. All right, then I haven't seen it if you're not filing.
All right. Thank you, Dr. Urbana, and thank you, Ms. Alexander.
Thank you.
All right, our next order of business is an amendment to 1 VAC 20-20-30 relating to the board's quorum requirements. Ms. Cole?
Well, good afternoon, Chairman Brinks, members of the board. I will be with you for the next 3 agenda items, so I will just stay here. So I am proposing an amendment to 1 VAC 20-20-30 as it relates to the definition of a quorum. As we know, we have 2 new additional members of the board. And so pursuant to the Virginia Freedom of Information Act, particularly 2.2-3701, a meeting is defined when sitting physically or through electronic communication means, as a body or entity or as an informal assemblage of as many as 3 members or a quorum. So we are changing our definition of a quorum in our regulatory code from 2 to 3. We are aware that this regulation you have in front of you does not reflect structural changes since the creation of the department, as well as it relates to administrative authority of the secretary. At the end of June, we conducted a periodic review of our regulations, so we will present this amendment as well as, this regulation as well as potentially 4 others for amending by the October board meeting. So for now, we're just changing the definition of a quorum.
Thank you, Ms. Cole. Members have any questions or comments of Ms. Cole's? And I'd like to say I appreciate the reference to the larger regulation from which this came, because I was frankly a little perplexed when I went in and read it. So I appreciate that you're going to be coming forward with an updated version. Members have any questions or comments of Ms. Cole's? Does any member of the public wish to be heard on this item? If not, I'll entertain a motion that the board adopt the proposed amendment to the regulation.
Move that the board adopt the department's proposed amendment to regulatory action 1 VAC 20-20-30.
Is there a second? Second. Been moved and seconded that the board adopt the proposed amendment to the regulation. All those, the secretary will call the roll.
Chairman Brink?
Aye.
Vice Chair Dr. O'Bannon?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Barron?
Aye.
The motion passes 5-0. Next item on our agenda is a series of proposed delegations of authority from the board to the department. This item was first heard on June 22, and further consideration was deferred until today's meeting. So, Ms. Wallace and Ms. Coles.
Good afternoon, members of the board. Nice to see you all again and meet the 2 new members. When the board last met, Ashley Coles and I presented on the updates to the delegations of authority. Last adopted in 2019, the updates reflect the many additions, deletions, and amendments to the Virginia election law. Generally speaking, the State Board of Elections is authorized to prescribe standard forms for voter registration and elections, and to supervise, coordinate, and adopt regulations governing the work of local electoral boards, registrars, and the officers of elections. The department conducts the board's administrative and programmatic operations and discharges the board's duties consistent with the delegated authority. We hope the board has had a chance to thoroughly review the supporting memos provided during the meeting. Does the board have any outstanding questions regarding the updated delegations of authority?
So, I do have one question on an item that you separated out, which is the forms. I think you had 11 separate forms that are required, plus all the campaign finance disclosure. Would it be your idea that these be separated out and be made subject to a separate motion?
No.
All right. Do the members of the board have any questions or comments about, this, massive delegation of authority?
I also have one quick question, and I did share this with the commissioner. It's on the first page, and it's new language. It's 242105, which says the board may accept voting and election materials translated by volunteers, but shall verify the accuracy of such translations. And I'm just, is that something straightforward that is not going to be a problem?
So, I guess your question is to make sure that the translations are...
It's new, and I just feel a little bit of, angst with passing that straight to elect, or without it maybe coming back through us. If you'll just offer us a update in a year or something about it, it would be...
We'll be happy, Mr. Chairman, to, after we've developed the forms and, worked with, the translation services, to bring them back before the board.
Thank you.
Absolutely.
If I could ask the commissioner, when is this requirement imposed?
So this is, if I understand
It is effective September
September.
1st, yeah.
September. And we're reviewing now. The only locality currently covered under this is Fairfax County, and they are already in compliance. We anticipate additional data in December of this year on the community survey for the census, which will potentially add additional localities. And it is the goal of the department to ensure that we are providing this service to the localities going forward. So, but yes, as Fairfax County after September 1st, as this section is in place, we will bring these before the board so the board can have a chance to review them and raise any concerns that they may have.
Thank you.
I have a question, yes. My question is about, translated by volunteers. Why you specify volunteers? Why can't be someone is, paid to do this job? Is that, within the law to hire someone to do it?
So this is the language directly from the code, from 24.2-105. So that was mandated by the General Assembly. So I cannot speak to why volunteers specifically, but.
Mr. Chairman, just as an FYI, I have no intention of using volunteers. As long as I'm commissioner, we will contract with a professional translation service to assist us in making sure that we get the correct language. I think that that's absolutely vital to make sure that we treat those who are more comfortable in a minority language, that they get the best service as possible. So I appreciate you bringing that up.
I appreciate the board and the commissioners' time looking at it.
All right, additional questions or comments on this item? If not, I will entertain a motion that the board adopt approve the proposed delegations of authority set out in today's. So moved. Is there a second?
Second.
It's been moved and seconded that the board approve the proposed delegations of authority. Does any member of the public wish to be heard on this item? If not,
Chairman, would that include rescinding the prior delegation motion?
I believe.
I was just reading the
I-
suggested motion here, to rescind the prior,
Yes, sorry, couldn't quite hear you the first time.
So we rescind
To
2019 plus the small one that we did at the beginning of this year. And all of that is incorporated into the delegation that we have before us today, including, and I'll go back to what I brought up before, including the delegation from the board to the department to prepare the plus campaign finance disclosure forms, that are specified in, your memo.
Correct.
All right.
If anybody has insomnia, I'll give you my copy of the book.
All right, additional questions or comments? If not, Secretary will call the roll.
Chairman Green?
I vote aye.
Vice Chair Dr. Lynn?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Merritt?
Aye.
The motion passes 5-0. Thank you. Ms. Coles, welcome back. Next item of business is proposed training standards and materials for officers of election. Ms. Coles?
Yes. So pursuant to the Code of Virginia, 24.2-103D, the State Board of Elections is required to set the training standards for officers of elections and develop standardized training programs to be conducted by the local electoral boards and the general registrars. The board is required to review the standardized training materials every 2 years, in the year immediately following a general election for federal office. So it is time for the board to review our proposed training standards. We currently have in front of you the Office of Elections Training Standards that I believe was reviewed either in 2017 or 2018. We haven't made any substantive changes, but we have updated the standards to reflect code changes. So these current standards are updated to new provisions of the code or amended provisions of the code. And then we have provided you all of the chapters of the training standards for officer of elections. So this serves as a foundation and a guideline. Localities do also offer additional training for officers of elections, and we have those standards indicated here. And we're also providing you with the quiz questions that are associated with each training. And we amend this yearly, especially after legislative changes. We are continuously updating these training standards.
Members of the board have any questions or comments for Ms. Coles? So this training packet includes, could you go on to the items that are the subject headings?
Sure, I don't have...
For officers of elections. The reason I ask is I think it's valuable for the public to understand the kind of training that the local election administrators go through in order to administer their elections.
Absolutely. If I may grab my work electronic device, I didn't want to print out all 50 pages. I wanted to see a tree. So I'm going to grab it. And I will pull up all of the subjects for you. So there are a series of topics covered in the Officer of Election Training Standards. So this includes a general introduction to elections in Virginia, kind of giving a brief overview of like the local electoral board, general registrars, and the Officer of Elections. We also have Officer of Election Basics. So this covers what is an Officer of Election, their appointments, qualifications and terms, job duties, functions and roles, election day overview, forms and paperwork, and other resources. We also have who is allowed in the polling place on election day. So this covers the classes of individuals allowed and the restrictions on the classes of individuals allowed in the polling place on election day. Training materials cover checking in voters, so their legal required check-in procedures, and also what to do when there's missing or incorrect information. Training standards include an introduction to provisional ballots and the policies and procedures around provisional ballots. It has emergency preparation and response, so a standard just overview of what to do in case there's an emergency, what to do after an emergency, and they provide sample scenarios. So some scenarios include if there's a short of election officials or there's an electronic poll book malfunction. Our training standards include accessibility and adequate. So what are our legal requirements? Providing assistance for individuals who require them on election day, polling place setup for accessibility and ensuring ADA compliance, adequate, and also curbside voting. And we have prohibited area and activities. So what is unlawful in the polling place, and in the prohibited area, what constitutes a prohibited area. And then we also have understanding accessible ID rules when checking in voters. And finally, we have Chief and Assistant Chief Officer of Elections duties as it relates to those roles specifically.
All right, thank you. I appreciate your giving that overview, just to give an idea of what kind of training the officers of elections are responsible for.
Yes, they do a lot, definitely.
Additional comments or questions of Ms. Cole? Any member of the public wish to be heard on this agenda item? If not, I'll entertain a motion that the board approve the proposed amendment. I'm sorry, I'm ahead of myself. Entertain a motion that the board approve the proposed changes to the training material. Okay, is there a second?
Second.
Been moved and seconded that the board approve the proposed changes to the training material. Any additional comments or questions? If not, Secretary Cruz, will you call the roll?
Chairman Brink?
I vote aye.
Vice Chair Dr. Bennett?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Mayor?
Aye.
Motion passes 5-0. Thank you, Ms. Coles. Ms. Coles, while you're here. Our next item of business is an amendment to the board's electronic meeting policy.
Yes. So since 2018, the General Assembly has conducted many amendments and revisions to electronic meetings, or meetings conducted through electronic means in the Virginia Freedom of Information Act. So as now permitted by 2.2-3708.2 of the Code of Virginia, public bodies may hold meetings where one or more members participate by electronic communication means, as long as the meetings comply with the heightened procedural requirements set forth in 2.2-3708.2. So the board's previous electronic meeting policy was last updated in 2015, so these revisions are needed to ensure compliance with the new statutory requirements. Now, while I won't discuss all of the policy changes, I would like to note that during the declared state of emergency, the board was complying with the provisions that are indicated in this section of the code. So this is just updating our policies to make sure that we have those changes in writing. And then I would also like to mention a change to an individual member's attendance. So on or before the day of a meeting, an individual member is allowed to participate through electronic communication means if they notify the chair of the board that they are unable to attend the meeting due to a temporary or permanent disability or other medical condition that prevents their physical attendance, as well as a family member's medical condition that requires the board member to provide care, and so they cannot attend the meeting in person. This also allows for a member of the board to participate through electronic communication means due to a personal matter. However, please note that if the member is participating through electronic communication means because of a personal matter, that is limited each calendar year to 2 meetings or 25% of the meetings held in that calendar year, whichever is greater, rounded to a whole number. The member must notify the chair. The reason for participating through electronic means must be in the meeting minutes, and they must specify the nature of why they are participating through electronic communication means. And if a member's participation from a remote location is disapproved, the disapproval shall be recorded in the minutes with specificity. That is my summary.
All right, do members have any questions or comments of Ms. Coles?
Ms. Cole, I'm actually on the same place you are.
Yes.
It's page 198, section 3, second bullet point.
Mm-hmm.
theirs and they or them or?
Yes.
Thank you.
Well, actually, I have a more pertinent question there. It says if the participation is disapproved, do I get to make this decision?
I mean, it's up to any member if they disapprove.
Is that right?
Yeah.
That might merit some additional investigation. All this power. Gone to my head. Just to clarify though, you still need a quorum of the
Yes.
board physically.
Yes. So for any meeting that's held through electronic communication means there still needs to be a quorum physically present, no matter what.
All right. My other, this is more of a comment than anything else. One of the side effects of the pandemic has been expansion of the ability of the public to participate and to view our meetings through electronic means. What this addresses is the members of the board and their participation. It doesn't go to either incentivizing or addressing question of the public viewing and participating, does it?
No. So this, under Section 2 of our meeting requirements, so we do have, when a board is conducting a meeting through electronic communication means, that members of the public shall be provided substantially equivalent communication means through which to observe the meeting, and they shall be provided the opportunity to comment when public comment is customarily received. So this is still not to limit any public participation. They should still be able to view like we currently do. We have WebEx available as well for public to participate.
Members have additional comments or questions? Do any members of the public wish to be heard on this agenda item? If not, I'll entertain a motion that the board approve the proposed amendment to its electronic meeting policy.
So moved.
Is there a second?
Second.
Moved and seconded that the board approve the proposed amendment to its electronic meeting policy. Additional comments or questions? If not, Secretary.
Ask a question.
Call the roll.
Chairman Green?
I vote aye.
Vice Chair
Can I ask a question?
Mr. Haley Green? Aye. Ms. Chang?
Aye.
Delegate Harris?
Aye. Motion is approved 5-0.
All right, I'm sorry, I'm
You were
Ask a question.
Our next item of business is party abbreviations for regular and special
Ask a
election
question.
ballots. Mr. Nichols.
Good afternoon, Mr. Chairman. Thank you, and welcome, members of the board, and to the new members of the board. It's very nice to meet you both. I'm very happy to have you all working with us. As with each election, there are often times when general registrars and electoral board members would like to abbreviate the party names on the ballot just to condense and provide space. Those abbreviations need to be approved by the state board. Democratic and Republican are fairly typical, and we keep our recommendation in here keeps that same scheme. We did have a bit of an issue with the Libertarians and the Liberation Party. Those are both recognized political parties, not official 24.2-101 parties, but 24.2-613 recognized political parties. They have met all the requirements to have candidates on the ballot with their particular name. As you can see in the documents we provided, we did reach out to both the Libertarian and Liberation Party with the issue of the potential confusion there. We didn't want to list them both as L's because that's a really bad idea. But we did offer them some options and gave them the opportunity to tell us what they would like to use. So they have provided some primary abbreviations they would like, and so we've included those as part of the board's working papers today, as well as some additional options. It's important also to note that when a locality uses abbreviations on the ballot, They are required to post a sign within each polling place, in 2 places, that shows what those abbreviations mean. So that is information that's provided to the voters, before they get their ballot.
So every polling place, every precinct will have
It'll have a sign that says,
L and LP or whatever it is
Yes.
that we approved, for the, Libertarian and Liberation parties.
that's correct.
Does the board have any questions or comments?
The Liberation Party, are they suggesting the LDP and the LDP?
They've suggested those as additional options. My guess is that, most general registrars and electoral boards would go with just LP. But those are additional abbreviations in case something were to come up. It gives us some options.
So the staff's recommendation is D, R, L, and LP
With the addition of the options,
of the options, local options.
local options, yes.
Board have additional,
Dave, I'm looking at page 202, and CDR, Libertarian, Libertarian, then I see Liberation a second time with different initials.
Yeah, that third column under abbreviation options, what we are going to prefer to go with will be, the L and the LP. But if there's some issue that comes up that we have unforeseen, that we don't anticipate, that makes things appear wrong on the ballot, would give us additional options without having to come back to you.
So we're gonna vote this, and that's a contingency that's up to you.
That's correct.
Okay.
Yes.
Thank you.
additional questions or comments? Does any member of the public wish to be heard on this agenda item? If not, I'll entertain a motion that the board approve the party abbreviations as presented by staff.
I move that the board approve the party abbreviations as presented by staff for general and special elections being held during April 30th, 2022.
Is there a second?
Second.
It's moved and seconded that the board approve the party abbreviations as presented by staff. Any additional questions or comments? If not, Secretary LaCruz, will you call the roll?
Chairman Briggs?
I vote aye.
Vice Chair Dr. Bennett?
Aye.
Secretary LaCruz? Aye. Ms. Chang?
Aye.
Delegate Barrett?
Aye.
Motion passes 5-0.
Thank you.
Thank you, Mr. Nichols. Next item of business is an update on the work of the Advisory Review Work Group, which will be presented by the group's chair, Lisa Coteen-Gurchik. The board will recall, and the new members of the board will learn, that the work group was established several years ago, and after a suspension of activities due to the pandemic, it has been meeting for the past several months. So, welcome, Ms. Gurchik. I look forward to hearing your status update.
Thank you, Chairman Briggs, and good afternoon to you and the members of the board. Thank you for inviting the work group, the Advisory Review Work Group, to give you a status report on the progress of our first assignment, which was to develop benchmarks to measure a successful election. As you mentioned, if we look at the next slide, a little background on the work group itself. It was established by the board by resolution in October of 2019. The board appointed 13 members, 3 of whom represent the Virginia Registrar Association, 3 from the Virginia Electoral Board Association, 1 from the Virginia Association of Counties, 1 from the Virginia Municipal League, and 5 citizen members. The board appointed the chair as a citizen member from among the citizens, and the board selected a secretary as required by the resolution. The work group first met in February 2020, but due to the COVID-19 emergency, was in hiatus and resumed monthly meetings in March of this year. We were meeting virtually until July. And we adopted bylaws in April of this year. Next slide, please. The starting point is what constitutes an election and what constitutes success. And the work group interprets an election to cover the entire process from voter registration through certification and post-election audits. The work group considers the concept of a well-run election rather than a successful election because it is not as subjective a concept. Success is definitely subject to various interpretations, and also, unless there is a true debacle, such as an election where a candidate commits blatant voter fraud across the board, every election is, in fact, a success because there's a winner and a loser or a referendum is passed. So given that, on the next slide, the work group developed a definition of a well-run election. And that is accessible, efficient, transparent, secure, and accurate so the public can be confident in the election results. After defining a well-run election, the work group read the literature. There is a fair amount of scholarly literature out there, and we heard from some experts who spoke to us, and then read about the work of identifying approximately 45 elements of an election and 70 sub-elements. Then we categorized them according to these 5 criteria that you see on the screen. And we are now reviewing and refining these elements and sub-elements. Next slide. The Department of Elections consultant is currently devising measures, both quantitative and qualitative, for each item on this list of 45 elements and 70 sub-elements. The work group will then review the suggested measures. Much of the data needed to conduct an evaluation already exist and are routinely collected. You can find them on the department's website, both raw data and the department's own post-election results. The report that the department puts together after each election. Examples of the kinds of data collected would be the speed of processing absentee ballot applications, the numbers of newly registered voters in that election who are casting ballots, the precinct sizes, analysis of online complaints, and election results reporting. You'll also notice that we have here measuring the voter's experience. This is harder to do, but we recognize the importance of measuring the voter's experience, although we're aware that the voter's perceptions are subject to personal biases and expectations. Learning how well voters understand the process will tell us how to enhance voter education. For example, simply having a poll worker explain the ballot to a voter. An example from my own experiences, there were 3 candidates for Soil and Conservation Commission in my precinct, and there were 3 slots. A voter could vote for all 3. I explained that to a voter. There are 3 possible votes, and there are 3 candidates. Here's your ballot. There are 2 major reasons, in the next slide, to evaluate data. One, the obvious objective, which is to establish benchmarks showing whether any given election was well run. Furthermore, such information would support the efforts of this board and elect and the local registrars and electoral board members across the Commonwealth to make improvements in elections on an ongoing basis. Continuous improvement would keep Virginia at the forefront of election management nationwide. We have one key concern, and that would be slide 8. And that is additional resources might be needed to collect and analyze all the data necessary to measure all the elements and analyze them to say whether an election was indeed relevant, and also to make recommendations for improvement. And finally, we look at our next steps. The work group is preparing a report of the elements and sub-elements beyond the statutory and regulatory requirements. I'd like to note that we assume compliance with the law, that simply checking off whether or not something was done is not really part of this entire exercise. And then we would like consideration of a second phase to address the actual implementation. In other words, conducting evaluations, who would do it, and how. And thank you for giving us this opportunity. I'm happy to answer any questions.
Thank you, Ms. Durchik. I want to thank you for the initial steps that you've taken on a huge kind of project, because what you're doing is trying to do both objective measurements of what a well-run election is, as well as the subjective element of was the voter serviced efficiently and in such a way that they left the experience feeling that they had confidence in the process. So it's a huge task, one larger than I realized, that we've given you, and so I appreciate the first steps that you've taken, and I'm looking forward to the next steps that come along. Other members of the board have questions or comments? Dr. O'Bannon.
I'd actually, thank you very much. Commissioner Piper, can you say a word about the consultant? How they got there?
Yeah, thank you, Mr. Vice Chairman. The consultant is, works through the contracting process that the Virginia Procurement Act and has set up. So we've worked with her for a number of years on a number of different projects. She has helped develop our last couple of strategic plans. She's for the Department of Elections, yeah.
What's her name?
Her name is Jacqueline Anderson.
Thank you.
You're welcome.
And then, one last thing. You all are the successor to a work group that was heavily supported by the EB and the GR community. And I don't think there's quite as much representation on what you are, but I hope you all are making the most use of your contacts there and including them in your deliberations. Because I'll just say, one of the really interesting things to me, and we just did, approve the training, is that these folks get trained and they're all locals and they all have perceptions. It might be interesting to look at data on their response to the training they've gotten and some other specifics that they might have. So anyway, thank you.
6 of the 13 members are,
Pretty well done.
yes. 3 of the members are registrars, and 3 are electoral board members. We rely on them pretty heavily.
In terms of timing, your next steps, what do you envision timing for the preparation of the reports of the elements and sub-elements, and then that's when we consider phase 2?
Yes, by October.
by October?
Yes, you had initially given us the charge to do this by October, and we have every reason to believe that we're right on track to do that. It might be a little bit interesting because the members of the election community who are members of the work group are pretty busy for the next few months. And trying to figure out how we're going to meet and/or provide them material to review and get feedback from them is something that we're addressing at our August meeting.
That's one of the side effects of Virginia's peculiar, if it's a year that ends in a number, it's a year that has an election in it. So you're faced with that challenge. You also mentioned in the cover memo that you provided to us that you're looking forward to future assignments. One of the things that I'd like to do is to talk to other members, get their feedback on what their suggestions are for the work group going forward. But I think we've given you enough to do for the moment.
Very good, thank you. And now, let me ask you, when you say talk to the members, are you speaking to your colleagues on the board or talking to us about future assignments?
Talking to other members of the board, now that we can talk to each other. All right.
Thank you so much. Sorry.
Did you do a formal ask for funding, or is that just on your slide as a?
No, I made no formal ask for funding.
Okay. Additional comments or questions? All right.
Real quick, I'd just like to acknowledge Tammy Beard, who's also on your group, who's from my home county. She's here today with us.
Ms. Beard, I spoke with you before your appointment to the work group, and I'm glad to see your participation.
Thank you.
Thank you. Additional comments or questions? If not, thank you, Ms. Richard. All right, our final item of business before going into closed session will be public comment on any non-agenda item. Does any member of the public wish to be heard on an item not on today's agenda?
First, I have, his name is Damien.
Yes. Going back to agenda item on electronic meeting policy. Is there a reason why you're not including elect and any of its working groups as part of this policy?
I'm sorry, could you repeat your question? We're having electronic problems.
Okay. Going back to the electronic meeting policy, is there a reason why you are not including elect and any associated working groups with elect as part of this policy?
Not to the best of my knowledge. I believe the policy that we adopted had to do with meetings of the board itself. And I don't believe that it addressed any work groups or subgroups.
Mr. Chairman, so with regard to elect, our meetings are not public meetings. You as a board are public meetings. The work group that Lisa just presented on is considered a public body, and they're governed by Freedom of Information Act laws as well. The policy that we have in place is just a clarification and a understanding of what the board's policies are. It's not necessary or required that the board have that policy because you're still under the Freedom of Information Act, but so is the work group. And the work group cannot convene without a quorum in person. It's all very similar So while I appreciate the question, it's not that they're being disincluded, it's just, it's not a requirement.
Thank you, Commissioner. Are there additional individuals who wish to be heard? All right, in that event, I will make a motion, that, the board go into closed session for the purpose of consultation with legal counsel and briefings by staff members or consultants pertaining to actual or probable litigation or or litigating posture of the public body as authorized by section 2.2-3711A7 of the code in accordance with Virginia Code section 2.2-3712F. Carol Lewis from the Office of the Attorney General, as well as Christopher Piper, Commissioner of Elections, will attend the closed session because their presence will reasonably aid the board in its consideration of a topic that is the subject of the meeting. Is there a second?
If you want to include, Daniel and, Franchell in that.
What about?
Right. Yeah, I'd amend my motion to include Mr. Persico, as a participant.
Second.
All right, it's been moved and seconded, and this can be done as a group vote, so all those in favor say aye.
Aye.
Opposed? Motion passes. And with that, we will go.
It really is very cold right here. Where are the apples?
Yeah.
All right, guys, we good to go?
Ready to go? All right. I move to reconvene in open session and take a roll call vote certifying that to the best of each member's knowledge, one, only such public business matters lawfully exempted from open meeting requirements under this chapter, and two, only such public business matters as were identified in the motion by which the closed meeting was convened were heard, discussed, or considered. Is there a second?
Second.
Been moved and seconded. Secretary of the Cruz, will you call the roll?
Chairman Brink,
I vote aye.
Vice Chair Dr. Lynn.
Aye.
Secretary Cruz. Aye. Ms. Chang.
Aye.
Delegate Barrett.
Aye.
The motion passes 5-0. Do I hear a motion to adjourn?
So moved.
Moved, is there a second? Moved and seconded. If we adjourn, all those in favor say aye.
Aye.
Opposed?